So, welcome back to another episode of Money and Medicine. We strive to be the most trusted platform, educational platform for medical professionals. So, we truly hope that you do enjoy today's episode. So, today we've got one of the thought leaders in the market industry. I must personally say, Shamini, I've worked with you before. I've enjoyed working with you before, and I've learned so much. So thank you so much for availing yourself today. And I think just as a start from my end, how did you join the industry, got into the fiduciary industry, and how did you get to where you are today?
Yeah. Thank you, Stefan, and thank you, Werner. It's a wonderful opportunity, and thank you for the invitation. So I am an admitted attorney. I've been one for the past 16 years.
Okay.
And I started out really as a general practitioner, as we all do. And around 10 years ago, I was offered this opportunity in the corporate world as a legal advisor for a trust company. So they had a head office in the Isle of Man and Mauritius, and then I was appointed in South Africa for the South African branch. So I found myself in the deep end then, because my knowledge on trust law was really academic. Whatever I learned as a student. And all of a sudden I had to administer trusts, I had to register trusts, I had to do estate planning and advise clients on that. So it was difficult in the beginning, and then I applied my mind, did a lot of research, and also, through the years then gained that experience. Spent around 5 years in the corporate world doing that, and then I was offered this wonderful opportunity to come back to practice as an attorney, and specifically in the fiduciary space. So when you talk about fiduciary matters, that typically includes estate planning, wills, deceased estates, and on top of that, in trusts, company administration, and on top of that, I'm appointed as a conveyancer as well, or admitted as a conveyancer as well. So that ties in nicely with the fiduciary sphere of work that I do. I regard myself as a specialist now, specifically in trusts, and we do a lot of work with clients when we deal with their trusts. We obviously also deal with their estate planning, with their wills, and then ultimately with the deceased estate, as part of that relationship with the client.
Okay. Shamini, we know estate planning is a very important topic when it comes to financial planning, and aspect of financial planning that's often overlooked. A lot of wealth we've seen in the past gets lost due to ineffective estate planning. So maybe for the listeners that is new to the concept, just a brief explanation of what is estate planning and why is it important?
I think in absolute the simplest terms, estate planning is looking at your assets, looking at your wealth, and then seeing how you can simplify it, how you can protect certain assets where risks are associated with those assets. Shares in a company, for instance, where you start out a new company. What are the risks associated with that new venture, that new business venture? How do you protect your more solid assets? When you deal with your assets, how do you retain your legacy and protect your legacy for your heirs? And a part of that, of course, is to see from a tax point of view, to do the planning. A lot of people think that estate planning revolves around tax planning. It isn't. It's a myth. Yeah. It's not around tax planning. You obviously get tax benefits when you plan properly. Correct. Yes. But it's more about simplifying your assets and also then making it as simple and easy as possible for your heirs when you are no longer here to continue. And that's a very important aspect of estate planning, which I deal with a lot, is succession planning and then continuity. Yes. When you have a typical family, where you have a family business, a doctor who has his own practice, he is the practice. His patients will come to him for him. If he's not in a big environment or in a government or state environment, so his income is reliant on his patients, and he generates the income. So what planning does the doctor have in place when you think about continuity and succession? How does that practice evolve when he's no longer there? Yeah. A lot of family businesses, I find that, where they don't have proper succession planning in place. And as far as continuity is concerned, then it creates a problem. So those are the things that we address with clients when we consult with them for the first time as far as their estate planning is concerned.
Yeah, and I totally agree to that. You mentioned succession, and you also mentioned, continuation of the business after there's a passing or a death of someone or the professional. And I think what we've seen is a lot of medical professionals that we deal with are first generation or graduate professionals. So they sit with a situation where, if I can say this, the sandwich generation, where they have to look after ascendants, but also or have to look after financial dependents. And ineffective estate planning is almost, it keeps people there. It keeps people in that situation where the next generation always starts with building up a new family business or building up a new practice, where they don't build from a foundation which was laid due to effective estate planning.
Absolutely.
And I think something that speaks to this quite often is a will, and that is overlooked is a will. So if you don't mind, just in layman terms, what is a will? And why is it important?
Yeah, it is so important, Stefan. And people really, like you say, neglect that part of the estate planning, the will part. Now, the will is basically a document which reflects your wishes as far as your estate is concerned. In the most simplest terms, is who gets what. But it also governs how your estate is dealt with, by whom your estate is dealt with. What happens to the minor children in the case where a husband and wife passes on simultaneously? Have you appointed guardians? Is there a testamentary trust required for minor children? How do you protect minor children's assets? The reality is that although unlikely, very possible that you will find yourself in a situation where you have a husband and wife dying simultaneously and there are minor children. Now, in South African law, what happens with a minor child's inheritance is it's passed on or paid over to the Guardians Fund and managed by the Guardians Fund, which is a government fund administered by the Master's Office, Master of the High Court. It's a low-risk investment. There are certain administrative challenges when you want to claim on the minor child's behalf. And it's so easily alleviated by just putting a will in place and saying, let's incorporate a testamentary trust, which we can go into this conversation a bit more. But as far as the will is concerned, of the utmost importance is that you have something that reflects your wishes. And of course, there are certain formalities that also need to be complied with. You know, it needs to be signed in the presence of 2 witnesses, 2 independent witnesses. I always say to my clients, people who are not related to you and who are not mentioned in the will, and also go a step further, who cannot directly or indirectly benefit from your estate.
So that's something that's very important, because when we deal with clients who doesn't have a will in place, I think a lot of people just assume that if they pass on, the house would, for instance, go to the spouse that stays behind, or it will go to a child, or certain assets would be distributed to a specific family member. But it's very important to record that, because that's just a wish. If there's no formal document where you record that wish, it's going to be very, very difficult to execute it. On the topic, just before we move on the topic of the Guardians Fund, what happens if the money is being paid into the Guardians Fund? When can that minor child actually claim the money?
So it depends on what the age of the child is. So if there are guardians formally appointed for that child, the guardians will be entitled to claim on behalf of the child. So you will typically submit supporting documents to the Guardian Fund and a list of expenses, monthly expenses required. That process, unfortunately, is a very delayed process before you get, and that happens on an annual basis. So on an annual basis, the guardians need to apply to the Guardians Fund for certain funds to be received. You will then, if something urgent happens, your hands are tied. The guardians will have to pay for whatever expenses. For instance, medical expenses. There's an emergency with one of the children. They would have to fork out the money themselves and then afterwards apply to the Guardians Fund to get it back. Whereas if you have a testamentary trust in place, which you create in terms of your will, you will have that benefit of those trustees. The inheritance will be paid into the testamentary trust, and the trustees will administer it. You will have the power to nominate those trustees. in your will, and they will administer the funds, as opposed to this third party where access to funds are not as easily accessible as it is with a testamentary trust.
Somebody, we also know that a will makes provision for the nomination of a guardian. Okay, so in the absence of a will, what happens? Who is going to be the natural guardian of a minor child if, for instance, there's no parent, biological parent that can look after the child? What happens in such an instance? The reason why I asked the question, because you mentioned that the guardian can then claim from the guardian's fund, but who's going to basically be appointed as the guardian of that minor child to claim from the guardian's fund in the absence if there's no will? Yeah.
So that appointment needs to be formalized by some way or another. Firstly, you sit with two aspects here if you haven't nominated a guardian, where family members fight over the children, for instance, where a sibling think that they are better suited to be the guardians of the minor children and as opposed to another sibling, and they start fighting. It always ends up in the High Court, because the High Court, being the upper custodian of all minor children in South Africa, makes that ultimate decision, the Solomon, so to speak, as far as what is in the best interest of the children is concerned. And so if you don't have a guardian appointed, firstly, your children may sit in a situation where there's a fight over them and they are left destitute at the end, sitting, between a fight between two family members or two siblings. And then secondly, it needs to be formalized. So if all the guardians of all the family members accept that this is the natural guardian, it needs to be formalized by way of an appointment by the High Court. And that guardian will then be entitled to claim from the guardian's fund. So that process in itself is also a prolonged process to get the guardian appointed, where as opposed to you nominating a guardian in your will, that guardian automatically becomes the guardian, doesn't need to be formalized by any way or form.
Oh. And I think while we're on this topic, something that I also see quite a lot is a lot of clients or a lot of medical professionals that we deal with are quite concerned that their wealth that they've built up, or whether that's a life policy, their wealth is wasted and it's not distributed to financial dependents and to lay that foundation, as we said earlier in this podcast. A beneficiary trust is obviously ideal, but I think there's sometimes a concern that the trust might benefit from that wealth and then they sit with the same situation. So just for the sake of the listeners, can we quickly just break down what is a testamentary trust and what is the exact function of that testamentary trust towards their children or towards minors?
Perfect. The testamentary trust is only created in terms of your will, so you make provision for it in your will. And it's only created at the time of your passing, if you have minor children. But also, it's not only for minor children. If you have a child with a disability or special needs, or a child that needs to be protected from himself or herself, then you will also typically make provision for a testamentary trust in your will. That testamentary trust is then created when your estate is reported by your executor, and you will nominate the trustees who will act as trustees of that trust. I always say to clients, one of the guardians is always a good idea, or one or both guardians if you have two guardians. But I say to clients that consider to appoint an independent trustee to safeguard the assets of their testamentary trust. We have come across scenarios where trustees have misappropriated funds because there's no real safeguard as far as the master is concerned. You can imagine that if there are 20,000 testamentary trusts, the master is absolutely unable, and there's no capacity for them to go and sit and check what is in a bank account of a testamentary trust. So you need to trust the people that you nominate as trustees. And then that's why I say an independent trustee always safeguards that scenario. So in practice, what will happen is the trust will be created, and when the estate is finalized, the executor will then distribute the funds that is destined for the minor children or for your child with special needs to the testamentary trust. Those funds and assets, that can be immovable property, movable property, it can be cash, will then be taken over by the trustees to administer for the benefit of the beneficiaries. In your will, you can then say the testamentary trust must terminate at a certain point For instance, when the youngest child attains the age of 25 years or 30 years, or even 40 years sometimes, people get very conservative. Or at a certain date, or in the discretion of the trustees. So what will happen is your trustees will then be able to pay school fees, maintenance, holiday, enjoyment, anything. And they will have the power to invest those funds. Of course, annual financial statements must be compiled every single year for the financial period, and then also tax returns must be submitted for the trust. So it's regulated in a certain sense, yes. But the testator, the person who signs the will, is the person ultimately responsible to appoint the best trustees who will act in the interest of the minor children. I'll also advise clients to consider appointing trustees where they understand your moral and financial values.
Yeah.
Someone who understands what you would have wanted to achieve, because these are the people who are going to look after your children and assist them to achieve what you set out for them to achieve, and look after them the way you would have looked after them.
While we're on the topic of the testamentary trust, for me, I'm just thinking, a question that I get asked quite often is, who will pay for that testamentary trust? Okay, does it get paid from the estate? Whose responsibility is it to create the trust, the testamentary trust? And then thirdly is, how quickly does that testamentary trust gets created after a deceased?
Okay. So firstly, who sets it up? That would be the executor. Okay. So the executor, taking over and stepping into the shoes of the deceased, will then look at the will and see that a testamentary trust has been provided for in the will. As part of the winding up process, the testamentary trust will then be created. It will only really come into effect when the liquidation and distribution account has been approved by the master, and that account accounts for all the assets and liabilities of the deceased and what is left after all of the expenses have been paid. So if you have what is left, say it's R1,000,000 or 100,000 Rand, it will only come into real legal force and effect, even though it's been created in theory, when a bank account is opened in the name of that trust and the funds are then distributed, or the immovable property is transferred to the testamentary trust, where the trustees then administer the immovable property on behalf of the trustees. As far as costs are concerned, that would be the cost for the estate. So it's a part of the estate expense. It's part of an administrative expense of the winding up of the estate. And it depends on who you appoint as independent trustee. If you have a professional trustee, there will be certain trustee fees payable. It depends on who the institution is that you've nominated. So whether it's a professional trustee, whether it's an attorney, and they will charge their normal fees because they are entitled. Correct. That will be an ongoing fee, and then obviously the cost of the accounting. It doesn't need to be audited financial statements. It only needs to be compiled by an accountant. So it doesn't need to be an auditor who compiles those annual financial statements. And that will be a cost. At the moment, the accountants that I work with charge between 5,000 and 7,500 Rand per annum to compile the annual financial statements, and then also to submit the provisional tax returns and the income tax returns.
Shamini, something that we also get quite a lot is when we deal with early career doctors, just starting out, they don't have any children, they probably have a car, like some of them don't even have that. Is a will still required in that instance?
Absolutely. The reason for the will is not the value of your assets.
Okay.
That's not the reason why you will set up a will or sign a will. The reason for the will is to make it as easy as possible for your heirs and for the executor to wind up the estate. So you make it easy on your heirs. If you don't have a will, then you die intestate, and your estate will then devolve in terms of the Interstate Succession Act and the interstate succession laws. For instance, there's a formula that they apply then to say that if you have a spouse and 2 children, you will have a child's share, which is at the moment, correct me if I'm wrong, I think it used to be 125,000, I think it's increased to 250,000. So whatever is it would basically be divided between the spouse and the 2 children.
Sure.
Whereas in a typical scenario, what we get often, and the most standard will, is you leave everything to your surviving spouse, and if you should die simultaneously, everything goes to the children. Now, if you leave everything to your surviving spouse, we talk about a Section 4Q. So from an estate duty point of view, there's a huge benefit because there is no estate duty payable on a bequest or a life insurance policy where your wife or your spouse or your husband is the nominated beneficiary.
Okay. Something we actually spoke about that we also get quite often. What is the difference between a single will? So let's say you're dealing with a couple, or you're dealing with 2 spouses, and each of them having their own separate wills or having a joint will. And we won't see this obviously as advice, but based on your experience and recommendation, which route would you go and recommend? And what's the difference actually between the 2?
Yeah. So, it's really up to the client whether they want to deal with their separate wills or their estates in a separate will or a joint will. We advise our clients, irrespective of how you're married, whether you're married in community of property, whether you're married out of community of property, with or without the accrual, to sign separate wills. And the reason for that is really just a practical one. So the joint will, the original joint will of the first dying spouse, will then be surrendered to the master. And that's what happens in practice. So you've signed a joint will, you have an original, and the first spouse passes on. That original will is surrendered to the master's office as part of the winding up, reporting, and then winding up of the estate. That will isn't returned to the surviving spouse. It lays with the master, it's filed there, it's registered with the master's office. What we often come across then is that the surviving spouse thinks, I have a joint will, I've signed a will, I don't need to sign a new will. And when the surviving spouse then passes on, then we need to go back to the master's office 20, maybe 10 years later, maybe 20, maybe 30 years later, and then try and retrieve that original signed joint will, which you can imagine is sometimes impossible, and other times it just delays the winding up of the estate dramatically for a year sometimes, just to look, just searching for that original will. So there's nothing preventing spouses to sign their own separate wills. In any event, the principle in our law is testator freedom, and that means that every single person may, in a will, bequeath his or her assets or his or her share of the joint estate as they wish. The majority of the times, it's really we draft a mirror will for each of the clients. It's a mirror of each other. When the husband dies, everything goes to the wife, or let's talk in spouse terms. A partner dies, everything goes to the partner, and then to the children, and that's stock standard. Another aspect that people perhaps don't understand is that when you make bequests in your will, you have 2 categories of bequests. You have specific bequests. Those are items that perhaps of sentimental value or perhaps of a legacy value that you want to bequeath to a specific heir. So, for instance, you've inherited something from your grandfather and you want it to stay in the family, so therefore that specific asset will go to your sister. That's a specific bequest. We talk about the legacies. It's a definition, it's a synonym for a specific bequest. It's a legacy to a legatee. So you may have a situation where you want to make cash bequest to certain heirs, 100,000 Rand each to the grandchildren or whatever. Those will fall under the category of specific bequests. And then what is left, we call the residue of the estate. And the residue will then devolve usually upon the surviving spouse, and if not to the children.
Shamini, you also mentioned the importance of an originally signed copy of the will. Okay. So I personally had an experience of that where a couple of years ago when I got admitted as an attorney, my grandmother wanted me to be the executor of her estate, and I drafted a will for her. She was staying with my mom at that time in Cape Town, and she signed an original copy, and for some reason they wanted to send the original copy to me. I said to them, just keep it there, keep it in safekeeping. But they've used the South African Post Service at that time, and we all know there was a big strike, and the original copy got lost, and my grandma actually passed away during that time. We had a certified copy of the will, but the master of the court didn't accept it. They actually wanted to have the originally signed copy when we reported the estate. A long story short, that meant that she passed away intestate. Because we could, there was ways, and you would know best, where you can approach the High Court with an application and explain to them the scenario. Luckily, she had a very small estate, but how important is the safekeeping of that original copy of the will? And what do you advise clients? How many original copies do they need to sign? More than one? What is your advice on that?
Yeah, Werner, it is such a good point that you make. I sit now at the moment with 2 estates where we are struggling to find the original wills. And I have business cards attached to a copy, and I started calling around, phoning around. The one I found, the other one not yet. And you rightly say that the master will only accept an original signed will. My advice to clients is sign at least 2 copies. One to be kept with your financial planner or with your attorney, and then the other one kept by yourself in a safe. And very importantly also is for you to tell your heirs or your wife or your children where that will is kept. The safekeeping is one thing, but if nobody knows where it's kept, that creates another problem and another challenge to come across it. A lot of the times also, so what we do with our safekeeping of wills with our clients, we allocate a specific securities reference number to them. They also get a wallet-sized card that they keep in their wallet, which has a QR code where you can scan into and go to a PDF copy of your will. And then also the securities reference number and your name and surname is on that card. What is handy of that is if someone comes across your wallet and you've passed on, they will get this card and they will know exactly where the will is kept. So we have a couple of branches around the country. Our head office in Pietermaritzburg, we have an office in Durban, we have an office in Cape Town, and I'm also responsible for the Cape Town clients. But what we do then is we have a central system that allocates the security reference numbers. So if a client's spouse comes across this card of ours, we call it an access card, they'll be able to contact any one of our branches, and all of us know and have access to our database. So if your financial planner has a system like that, it would always be a good idea to keep it with your financial planner or with your attorney, as well as one copy with yourself. And then importantly, as I said, most importantly is someone must know where it is. Someone else must know, other than you, must know where it is.
Otherwise you won't know where to find it.
Exactly.
Then it doesn't mean anything.
Yes.
Shamini, we also know the world has become a very small place. People have assets, international assets in different countries. Some clients also decide to immigrate. What is the purpose of an international will, and how important is it to have an international will?
Yeah, you are so right, Werner. Over the past 10 years that I've been specializing in fiduciary matters, this question has come up over the past 2 years more often than ever before. And like you say, people are investing offshore, people are immigrating, people have children in other countries, they have assets in other countries, they have assets here and in different countries. The question really is, when we consult with clients on their will, is to establish the jurisdiction of your South African will. Will it cover your worldwide assets, or will it cover only your South African assets? Under circumstances where you have immovable property in another country, for instance in Portugal or Spain, or it doesn't matter where it is, I advise clients to have a separate will for that jurisdiction to deal with the immovable property. And the reason for that is really just a practical one. It's not because the executor appointed in your South African will not be accepted in that other country. It's more because of the inheritance laws that may apply to that country. And then also the process, we call it probate. So to have a South African executor acknowledged in a different country to deal with that asset through solicitors in that country, you will have to go through a process of probate. And that probate process, I'm now busy with a situation like that, has taken thus far, has delayed the winding up of the deceased estate by 4 months, thus far. We have only court-sealed copies now from the Master's Office. We've submitted it to the UK or the authorities in the United Kingdom. Obviously also at a large expense to the estate, because now you have to appoint solicitors in the other country who needs to deal and assist with this process of probate. So where you have immovable property, I say to clients, contact a solicitor. If you purchase the property from an estate agent, obviously they would be able to advise you in that country who a solicitor can be, or an attorney who will be able to understand the laws there, and then also appoint an executor to deal with that specific asset. If, however, you have an offshore bank account, and that's basically it, and the rest of your assets are all in South Africa, the South African will, dealing with your worldwide assets, will be sufficient.
Okay.
So we are very cognizant of what type of assets you hold offshore, but we also, in our will, we specifically state the jurisdiction of your will, whether it covers your South African assets, only your South African assets, or your worldwide assets. But a very, very important aspect that people also forget is that if you have an existing will in another country to deal with your immovable property because you have been given sound advice to have a separate will, the fact of the matter is if you don't tell your attorney or your financial planner or the person who drafts your will in South Africa about that will, and this South African clause, or South African will, the revocation clause, where you revoke all previous codicils and wills that you may have signed jointly or separately, you also revoke the offshore will.
Okay.
So that's a very important aspect. If you have an existing will offshore, that you advise the person, the will drafter, of that will so that they don't revoke accidentally that will. So what we say in our revocation clause, which is the first clause in our will, we say we revoke any will or codicil which you have previously signed relating only to your assets in South Africa.
Okay.
And that's very important. So then it doesn't revoke any other will in any other country.
Shamini, thank you so much. You've been so helpful. I've certainly learned a lot from this podcast. How can our potential listeners reach out to you?
Well, they can obviously contact you or Werner. That's the first. That's the first and foremost. You can contact me through Werner and through Stefan. Our website, it's www.tmj.co.za. For Lighthouse, where our fiduciary function is performed, it's www.lhtc.co.za.
Well, Shamini, thank you so much. We really appreciate your time and efforts. And for our first-time listeners, we hope you enjoyed this podcast. We want to welcome you, and we also want to partner with you. So feel free to reach out to us on www.moneyandmedicine.co.za. We also share some other valuable information where we had conversations with thought leaders in the market and in the industry. And until next time, plan the plan.